welcome once again to 26 North Halsted. I'm your host, George Blaze. You know, from NSA whistleblowers to New York stop-and-frisk laws to concealed carry, so many things in the headlines today, and it's easy to get really emotional about things. And sometimes I like to get some perspective and talk about the legality of these issues, and it kind of helps me think about where I stand on them. Joining me now is my good friend Brendan Shiller, civil rights attorney. Brendan, thanks for spending some time today.
Thank you for having me, George.
How do you manage to get a day out of court? I mean, there's so much going on.
Because you asked.
That's a fantastic. Do you see the power I wield? Let's start. One of the main issues that I see out here right now is this New York stop and frisk thing that's been going on. Give us some background on what stop and frisk is and where it stands right now.
Well, the Fourth Amendment says that any detention or seizure by law enforcement has to be reasonable. There's a case called Terry versus Ohio from 30 years ago that said that officers can stop people for a brief detention without arresting them if they have a reasonable suspicion that they're engaged in crime. Now, reasonable suspicion doesn't really come from the Fourth Amendment per se directly in terms of how that's defined, because what the Fourth Amendment talks about is reasonableness. That's where the word Terry stop or stop and frisk comes from. Okay. You have a reasonable suspicion somebody's committing a crime, you can stop them and ask them a few questions. The frisk portion really comes from nowhere. It's a court made up. Well, if you stop to ask them and the officer feels his safety's in danger, that they may have a gun, he can then frisk them. Okay. He's not supposed to frisk them for drugs. He's not supposed to frisk them for any other type of evidence. He's supposed to frisk them only if he believes his safety is in danger. So you get a Terry stop that results in a stop and frisk. Strictly speaking, it's pretty much unconstitutional.
So what's going on in New York City primarily is that they've kind of profiled and said young African Americans that look from 15 to 21, we're just going to stop regardless of whether or not there's something going on.
You know, honestly, it's what goes on in every major city. They just actually made it a program, put a label to it, and we're proud of it in New York and been doing it for several years. I think anybody who lives in any major city knows that from time to time there's just random stops and frisks of young Black and Latinos. I think the court got it right earlier this week. They said it was unconstitutional. You can't just approach anybody for just as a matter of Fourth Amendment law. You can't just approach anybody and just stop them and frisk them. As a matter of equal protection in 14th Amendment, you can't do it based on race. So I think it violates the Constitution in two ways. I think it's very clear legally. I think there's a political question that needs to be addressed, though, because what you've heard in response to the legal analysis is, okay, maybe it's unconstitutional, but it's working, and it's the right thing to do. And it works because more Blacks and Latinos commit more crimes, so it makes sense that they're targeting more Blacks and Latinos. There's two problems with that. One, it isn't working. All the statistics show that there was a dramatic decrease in the number of stop and frisks in New York City over the last several years that at the same time coincided with a dramatic decrease in crime and violence. So there was no correlation, or I'm sorry, there was no causation between the stop and frisk and decrease in violence and crime. Okay. The other part of this is, and I think it's really important to take on the statistical myth, because even actually following the Trayvon Martin verdict, President Obama even made a reference to this. There's this statement that, well, it's assumed that more Black and Latino young men commit crime at a higher rate than young white men.
That's what you hear all the time.
It's false. You got to make a distinction between conduct and reporting of crime, which is often based on arrests. All the statistics show us that young white teenagers engage in drug use at about the same rate as young Black teenagers and young Latino teenagers. That's conduct. All the statistics show us that when it comes to violent conduct that's separated from poverty-based violent conduct, in other words, when you're talking about batteries, aggravated batteries, assaults, as opposed to armed robberies and gang violence, that there's actually a higher rate of aggravated batteries, and sexual assaults, slightly higher rate amongst young white males, teens in their 20s, than there are in that terms of that conduct amongst young Black or young Latino. What you get, though, is a higher crime rate because you get more arrests of blacks and Latinos.
So if you're out there targeting a certain group of people, you're stopping and frisking, chances are you're going to catch more of them, they're going to be charged more, and these are where the statistics are coming from as opposed to what's actually happening on the street?
10%, 90% of the stop and frisk resulted in nothing. 10% resulted in some type of arrest. Of those 10%, half of those were for marijuana possession of less than 2.5 grams. So now if you're targeting all sorts of black and Latino young men in New York, and the result is you have an increase in arrests for marijuana possession, the crime stats, which is what's actually collected by the FBI, who gets arrested for these crimes, show a much higher use of marijuana use by blacks and Latinos.
Because you're looking at crime stats and not actual conduct stats.
So now you arrest more black and Latinos for the crime, then you justify the arrest to say, well, we need to stop more blacks and Latinos for this crime because they're getting arrested more often. It's a terrible loop. It's obviously both racially biased and statistically biased in the most objective sense of the science, and so it's not only unconstitutional, it's not nearly as effective, it's not effective at all as the proponents claim.
Well, it's been a while now that